The most common questions potential clients ask on the first phone call is, can you win my stunt driving case? It's a legitimate question, but it's not a realistic question because winning is a term that varies. It depends on your speed, on your driving record, the prosecutor, the court, the officer, the time of day, and all other evidence. So let's first examine the use of the term winning, both legally and ethically. The Law Society of Ontario, the LSO, does not permit the use of the word winning when it comes to traffic cases. Slogans such as "we win or it's free" are banned for purposes of marketing and client consultations. In fact, the Law Society does not allow representatives to take cases in traffic offenses for free, promising an outcome before you pay. These type of slogans only really apply to personal injury or insurance cases where the legal representative gets their fee based on the settlement from the other party and not necessarily from the client themselves. In stunt driving cases in Ontario, if you are hearing "we win or free" on your phone call or consult, it may be time to hang up and look elsewhere. The legal representative would be acting unethically and illegally, and that's not a great start to your defense. So, can I win my stunt driving charges in Ontario? The term winning, it's not absolute. It's very subjective, and it depends on the penalties you are facing. Obviously, the ultimate win is getting your stunt driving charges withdrawn or dismissed. However, the law is written in such a way that the bulk of evidence falls on the radar or the laser. And once this is established to be accurate, it's very difficult to dispute the charge itself. So, is there such thing as winning a stunt driving case in Ontario? Well, again, once this radar has been established as accurate, the term winning becomes very subjective. Here are some examples of what some might consider to be a win. If the prosecutor is asking for jail time, then a resolution without jail time may be considered to be a win. If the prosecutor is asking for $10,000, well, then a fine of $2,000 may be considered to be a win. If the prosecutor is really pushing for stunt driving, then a lesser charge with no mandatory 1 to 3 year license suspension may be considered a win. So don't fall for the nonsense of promises of winning. Speak to a realistic stunt driving law firm, and whoever you hire, they better have a serious strategy in place based on the following. 1, based on cases very similar to yours in the same court. 2, that case should be resolved in the past 1 to 3 months because court prosecutors change. And 3, best and worst case scenarios. Remember, if the prosecutor sets the rules of the game, it's not your representative. So this means that a promise by your rep has no meaning until the prosecutor sets those rules of the game. So even if you're not hearing what you want to hear, be appreciative if the advice you're getting is realistic based on experience. Talk of winning and getting charges withdrawn without having seen the evidence or talking to a prosecutor, they have no meaning. So book a call today. Let's talk about your options and a realistic strategy.